Thank you, Chairperson. Chairperson, I will certainly deal with the questions from the honourable members, but we started this work way back in 2019 in terms of the 7 key priorities, and priority that speaks to building a capable and an ethical state. We've also worked closely with the External Audit Committee that had insisted that government and compliance, government risk and compliance must deal with the repeat findings. We've not been very successful on the repeat findings exactly because this unit is not fully operational. And also our internal audit together with the external audit with them on a quarterly basis. And we have designed out of the external audit briefings, we have designed a plan of action for the department to build into the systems that we can detect and prevent the work in progress. But the AG has also acknowledged the work that we are doing around compliance. So just one point in terms of the requests for performing work outside of the civil servants, or of the civil service, sorry, the applications that came to me in April of this year, 2022, I had to send it back to the designated ethics officer to do due diligence on every one of the applications. And I sent it back on this around about the middle of June. So we have not processed the request for doing work outside of the public service for this current year because that is still outstanding. In the meantime, I have requested that we advise the individuals that their request to do work outside of the public service has not been approved until we can complete the due diligence. And Mr. Mashlango is driving the process so that we can conclude the due diligence that will inform my decision whether to approve or not to approve. So there are a lot of the systems that's work in progress, but the biggest stumbling block has been the funded posts where there was no budget allocated to the funded posts. As part of the solution, I have requested that the funded posts, because we are very slow on filling posts and we've got a lot of slippage within our HR department, that the CFO in the meantime, we need to do a review of all the posts that has not been filled for more than a year, and that money be allocated to the GRC unit to fill those 4 critical posts that Mr. Mashlangu make a reference to. But we will continue to update the portfolio committee as we go on. But we do monitor the compliance side on a monthly basis. Thank you, Chairperson.
Thank you, Minister. I think let's then get the second presentation from the legal services.
Thank you, Honorable Chair. Thank you, Minister. Thank you, Deputy Minister. And thank you, Honorable members. The presentation that follows is the one on the legal cases that the department is managing. Chairperson, I would like to just give a brief because we have noted that the presentation is very long, but just to give a high-level synopsis of what the issues are going to be covered. And I will also go and deal with the summary in a high level. Now, the presentation generally, Chair, is looking at the cases as at March 2022 and the first quarter of 2022-2023 financial year. In the report, we have done an analysis of all the cases from the nature of the cases, the category of those cases, as well as their age analysis to say how long has the case been on our register and the current status, as well as the merits assessment. Merits assessment for purposes of members of the committee would be to say, do we have a good case as DPW or there's a good case by the other party? Now, then we also look at the cost implications of those cases to say how much has been claimed against the DPW and PMTE. And as well in the presentation, we're also looking at the dormancy of those categories of certain cases to say how much do we have in terms of dormant cases. And then we also deal with the statistics on the finalized cases, then expenditure thereof. And in conclusion, you will be seeing the statistic thereof. So in principle, the report, if you look at it, it's more statistical and then with a synopsis of what the merits are. We're trying to strike a balance between full reporting and also ensuring that we do not compromise full information of the matters that are still in court. We understand we are in a public platform. Thank you. And with the categories, you are going to see that we have categorized cases in terms of the areas like your construction-related matters, your leasing-related cases, and the motor vehicle-related cases as well, labor-related cases, SCM-related cases, then we analyze them. One of the critical things for the purpose of the committee, when we report now, I will try to confine ourselves on the most critical areas, which are your construction-related cases, leasing-related, and duty of care cases, as well as facilities management-related cases, because these are the ones that are driving high volume of cost. Thank you. We may go to the next slide. Another one, yes. There seems to be, yes. This is the summary. This is for Johannesburg Regional Office in Johannesburg. Now, for Johannesburg Regional Offices, if you look at their construction-related litigation cases, they have about 5. The 5 cases having good merits in favor of DPWR, and only 1 case with poor merits in favor of the contractor. Now, all these 5 matters were filed during the period 2019 to 2022. Now, you can see that they are fairly new, not old, and they are still active. 1 matter registered as dormant since 2013. There's only 1 matter which is a bit old. Now, the total value of these claims is about 91,071,851 rand 33. Why we say so? Construction is actually leading. That's why we started with it, and then leasing. Now, it's about the total cost 91,071,851.33. Now, on the leasing cases, there are about 5 cases registered. 1 is a very old one in 2007 and is due for write-off because recovery is not possible, it's difficult. The 4 remaining are active and only arose during 2018 and 2020. and the total value of the claims on leasing are about 3,079,031 rand 67 cents. 2 of the claims have been settled in full. Now, those 2 have been finalized. Now, if you go down a bit, we want to go to duty of care. Next slide. Now, the area that we also needed to look at is the duty of care related claims. Now, duty of care related claims, Chair and members, these are the claims arising out of the state as owner of particular facilities having a responsibility in law to ensure that the facility is well maintained, taken care of, and we maintain standards. Now, this is one area that is growing after construction and leasing. We are seeing a number of cases that are growing in different regions. Now, Johannesburg had about 3 cases registered in 2020 and 2021. One case, we have got poor merits, and it is due for settlement with the plaintiff. We have considered the merits. Now we're dealing with the quantum to say how much we're going to settle. The other 2 claims, DPW has got good merits because the facility in question and the road involved do not belong under the function of public works. So the value of all these claims is about 13,426,860,000. Now, we look at 2.8 dormant cases. We have about 1 for Johannesburg, and 2 litigation cases were finalized during the period under review. And the total litigation claims on the register for Johannesburg, we have about 25 that are active. Next slide. Now, the next slide, we're dealing with the summary of cases for Mmabatho Regional Office. The Mmabatho Regional Office, they do not have construction related, is the leasing related claim there, which is 1, which is payment for damages with good merits in favor of DPWI. There, since the plaintiff could not obtain registration of the property that we were intending to lease, we terminated, and now the plaintiff is trying to sue the value of the rental of the entire lease. The claim is dormant, it's no longer active. The plaintiff seems to have lost interest. Now, the breach of contract related claims, they have about 2 for Mmabatho. DPW cancelled and claimed damages. The first claim was registered in 2007. If you look at it, it's a very old one. The other one in 2015. However, both claims became dormant. One is due to loss of court file, and the other is untraceable defendant. The 2 total claims amount are 1.2 million. Now, ordinary goods and services, there are about 3 for alleged payment of service rendered registered in 2020 against the Minister and Provincial Government of Northwest, with DPW having good merits because there is no contract between Department of Public Works nationally and the plaintiffs. But the contract was with the provincial government. The claim is well defended. The total claims are about 2,018,658. Now you go down there, you look at dormant claims. Northwest has about 3. These are the claims that are not moving. Number of finalized matters, they've got 0 for the period under review. Total number of litigation cases, claims on the register for Northwest is about 7. Next slide, please. Now, summary for Pretoria Regional Office. The Pretoria Regional construction-related cases, there are about 8. 4 with good merits in favor of the department and 4 with poor merits. 4 claims filed in 2022 and 3 filed in 2021. 1 claim filed in 2019. So in terms of age analysis, we feel still within time, and the total value of the claims is 115,084,015 rand 3 cents. Now leasing as well is about, we have got about 4 claims registered in the workbook. 1 claim registered in 2013 with DPW having good merits, but it went dormant due to plaintiff having lost interest. 1 claim registered 2016 and plaintiff lost interest after rescission of judgment, showing that a full payment has been made by DPW of the rentals. The other claim arising 2018 and is dormant due to the plaintiff also losing interest. So most of matters that are dormant, you can see that plaintiffs are losing interest. Once you file the papers, they realize, no, you have a stronger case. They subside, leave the matter hanging. So the total value of the claims for leasing is about 77,043,130 rand 99 cents. Now you go down to duty of care. There's 1 claim registered in 2020 with good merits in favor of plaintiff. However, the quantum is disputed and the total claim is 6.3. Now in this case, although the plaintiff has a good case, now the issue that still need to be determined is the quantum of how much will the department and PMTE be liable. So the issue to be determined is actually quantum. So 4.5, you look at dormant claims. Pretoria is about 3, and the number of finalized matters, it is about 4. It's 1 duty of care claim where we paid about 50,000, and 1 construction claim for about 30 million rand, and 1 leasing claim for about 1.7. The last one, which was 10.1 million, which was area rental. Total litigation claims on the register are 19 for Pretoria Regional Office. Next slide. From Tata construction-related claims, we have about 1 claim registered 2019. DPW canceled the contracts due to poor performance. There is no monetary relief claimed by the plaintiff, but they are in fact requesting the court to be directed to go back to site. Now, the leasing-related claims, there's 1 claim registered in 2021 in respect of damages to leased premises, and the DPW has since the premises were not restored to their original condition prior to the termination of the lease. Now, the claim is about 76,224 rand 60 cents. Now, the other claim there is facilities management. The claim arose in 2021, is in respect of an application which was brought by an occupier of a DPWI building, and she wanted to be restored possession, which was a spoliation. There's no monetary value there involved. Then duty of care from Tata, there are about 2, both registered 2018 and 2019, fairly new. And the other claim is the plaintiff is saying that they have sustained injuries arising out of a DPW-owned property, and the other claim is out of the property owned by the provincial government. So the property, we are defending this second claim on the basis that the owner of that asset is the provincial government. Now, the 2 claims for duty of care, the value thereof, it amounts to 2,482,721. Now, Dormant claims from Tata, we have 0. Number of finalized claims, 0 during the period under review. Total number of litigation cases for this region is about 7. Next slide. Now, summary of Durban Regional Office litigation cases. For construction in Durban, there are about 11 registered claims, with 10 claims having good merits in favor of DPWI, and only 1 claim with poor merits against DPWI. And now 7 claims arose during the period 2016 to 2022, fairly new in terms of their age analysis. And 4 claims arose between 2013 and 2014, and they are all dormant. Total value of the claims are 116,218,988.92 cents. Lease-related claims, there are about 14 registered claims, with 11 claims having good merits in favor of DPWI, and only 3 claims with poor merits against DPWI. 12 claims arose between the period 2016 and 2022, and they are still active, while 2 claims which are registered in 2014 are dormant. There's no movement there. Total value of these claims is about 167,664,584.75 rand. On facilities management related claims, Durban is leading. There are 21 claims registered, 19 of which DPW has got good case, and 3 claims with poor merits against DPWI. 9 claims are dormant on the register. Total value of claims is 971,431 rand 50 cents. Now, let's go to the next slide. Now, if you look at duty of care related claims, there are about 6 claims registered, with 4 claims having good merits in favor of DPWI, and 2 claims with poor merits against DPWI. All the claims arose during the period 2015 and 2022. Total value of claims is 27,491,479 rand 13 cents. Now for Durban, we have about 19 matters that are dormant. And finalized matters, we have about 2, 1 land claim and 1 tender review, which were dormant and file closed at the recommendation of state attorney, because those matters were not moving. Total number of litigation cases on the register for Durban is leading by 56 for overall when compared to all regions other than head office. Next slide. Now, if you look at Fontaine regional offices, construction related claims, there are 7 claims registered, only 4 claims with good merits in favor of DPW, and 3 claims we have poor merits, and all claims arose during the period 2018 and 2021. 1 is dormant after DPW served and filed its plea. The plaintiff then subsided. The total value of claims for construction in Bloemfontein is 5,418,927 rand 1 cent. Leasing related claims, there are 11 claims registered with good merits in favor of DPWI. There's 1 claim where the DPWI is indebted to the landlord for an amount of 4,551 instead of 169,000, and we have tendered that. We're waiting for the landlord to accept. Now, the balance of the claims are outstanding rentals, due to the DPWI, and state attorney has been instructed to issue summons against the debtors. Total value of claims is 631,662 rand 99 cents. Next slide. With Fontaine on the care-related claims, there are about 2 claims registered with poor merits, the DPWI and DOJ, and the second one involved DPWI and SAPS. The one claim has since been settled by Department of Justice, as well as the damages and legal costs. So Department of Justice paid for the quantum of damages as well as the legal cost. The one claim is dormant since 2014 after withdrawal of notice of set down by the plaintiff. So the total value of the claims were about 3,688,950 rand 61 cents. Next slide. Now, if you look at the claims, there are about 2 for Bloemfontein, and then finalized claims, there are about 7 matters which have been finalized. We describe them fully down there. Total number of litigation claims on the register for Bloemfontein is about 28 matters. PE, construction-related claims, there are 11 registered claims, with 7 claims having good merits in favor of DPWI, and 4 claims with poor merits against DPWI. And all claims arose during the period 2015 and 2021. Total value of the claims is around 58,685,539 rand 27 cents. On facilities management related claims, there are 4 claims registered with good merits in favor of DPWI, and all claims arose during the period 2020-2021. Total value of the claims, 123,234 rand 22 cents. The claims are failing. Now, duty of care is 8.4. There are about 6 claims registered, with 5 claims having good merits in favor of DPWI, and only 1 claim with poor merits against the DPWI. All claims arose between 2019 and 2021. The total value of claims is 339,608,368 rand 2 cents. Now, 1 claim there is the driver of these claims, because it's about 211 million. Summary of the dormant claims for PE is 0. Finalized claims is 3. 2 is construction related claims, and we finalized it by writing off, doing a submission for write-off, because we could not, the sheriff returned a return of non-service. We could not execute the warrant. And 1 land-related claim was finalized through court judgment, dismissing application against the state. Total number of litigation cases on the register for PE is 26 cases. Next, summary for Nelspruit. Construction-related claims for Nelspruit, there are about 3 claims registered with poor merits against DPWI, although DPWI served points in limine, and all the claims are now dormant. Now, once the plaintiff you raise those points in limine, points of law, some of them, they went back. But if you look at the merits, they are poor against us. The claims arose during the period 2010, 2012, 2014, respectively. The total value of the claims is 2,873,986 rand 54. Some are old. Most of them, they need to be dealt with, their dormant. Listen related claims, there are about 3 claims registered with good merits, in favor of DPWI on 2 claims and poor merits on a single claim against DPWI, since the client vacated the building before expiry of the lease. So we're liable for the rentals. Total claim, all the claims arose between the period 2013 and 2014 and 2022. The total value of the claims is about 6.4 million. Facility management related claims, there are about 2 in Nelspruit, registered with good merits in favor of DPWI, since the farms which are the subject of the claim are under the custodianship of Rural Development, Department of Rural Development and Land Reform. The claims arose between the period 2014 and 2015. The total value of the claims is 24,549,985. Next slide. Now, the duty of care related claims. For Nelspruit, there are 4 claims registered with good merits in favor of DPWI, since the DPWI is not liable in law in all 4 claims, which have been defended. 1 claim is trial ready, the other are at the pleading stage. The matters arose during the period 2011, 2012, 2014, and 2018. And 1 matter is dormant since 2014, when the matter was postponed until further notice. Others are still running, although very old. Total value of the claims is 15,330,500 rand. Dormant claims, there are about 5. For Nelspruit, number of finalized litigation claims is 0. And the number of total litigation claims on the register for Nelspruit is 14. Next slide. Summary of Kimberley. Kimberley, for construction, there are about 4 claims registered with good merits in favor of DPWI. And since 2 claims, the 2 claims of 2005 and 2010 have been finalized. The 2016 claim, we are awaiting judgment. The 2021 claim is awaiting notice of set down for trial. I may not see very well here. So on leasing-related claims, there are about 4 claims registered on the workbook. There are good merits in favor of DPWI, and 1 claim of 2021 was dismissed, and the other claim has been referred for mediation. The 2020 claim is still at the pleading stage. The total value of the claim is 1,022,929 rands. On facilities management related claims, there's only 1 claim registered, and with good merits in favor of DPWI, since the claim was fraudulent and it has since been dismissed by court. The total value of claim was 107.60 cents. Dormant cases for Kimberley region, 0. Number of finalized litigation claims is 0. Total number of litigation matters on the register for Kimberley is about 9. Now, summary of Cape Town Regional Office litigation construction, there are about 4 registered claims, with 1 claim having good merits in favor of DPWI and 3 claims with poor merits against DPWI. The matters are still active at pleading stage, meaning the parties are still exchanging papers, and they arose in 2017, 18, and 2021. There's 1 claim which is dormant since 2016, which was filed in 2012 as a vexatious claim. Total value of claims for construction is 30,530,226 rand 24 cents. Leasing related claims, there are 3 claims registered with good merits in favor of DPWI. 1 matter is dormant since the client department has not been cooperating. The claims arose between 2017, 18, and 2021. Total value of the claims is 1.3 million. Facilities management related claims, there are 8 claims registered with good merits in favor of DPWI. 5 matters filed in 2022, 2 matters filed 2021, and 1 matter filed in 2020. Now, all the claims, if you look at them in terms of age analysis, they are fairly recent. These claims have no monetary implications as they involve pure court applications for other orders. Next slide. If you look at duty of care related claims, there are 3 claims registered with good merits in favor of DPWI. Since the DPWI is not liable in law in all 3 claims, the matters are being defended and trial has commenced in 1 claim. The remaining 2 are at the pleading stage. They arose in 2013 and the other one in 2019. 2 matters are dormant since the plaintiff is no longer taking further steps. Now, the total value of the claims is around 10,107,514 rand 7 cents. Now, dormant claims for Cape Town, we have about 5. These are matters that are not moving. Number of finalized litigation claims is 0. Total number of litigation cases on the register is about 21. For the last region, there is Polokwane. Polokwane has got about 4 construction claims registered, and they are all with good merits. All claims arose during the period 2014, 18, 19, and 2021. 2 claims are active, while the other 2 are dormant, since the plaintiff appears to have lost interest in the matters. Total value of the claims is about 2.9 million. Leasing-related claims, 1 claim registered with good merits in favor of DPWI, since the lease agreement was terminated with DPWI. However, sub-members of the client decided to remain in those barracks on their own volition. The claim arose in 2020 and is still active since the parties are still exchanging pleadings. Total value of the claim is about 3,980,732 rand 91 cents. Now, duty of care related claims, there are 2 claims registered, 1 with good merits in favor of DPWI, since the damages to the property in questions were caused by members of the community who were engaged on a strike and not negligence of DPWI. In the second claim, yes, the plaintiff has good merits because he got injured in one of our facilities. Now the issue of merits has been settled. Now what remains is the issue of quantum, to say what for those injuries sustained, how much should be paid. The experts, we're still looking to exchange expert reports. Next slide. Now for Polokwane, the dormant claims, there are about 3. Number of finalized matters, there are about 2. Total number of claims on the register is 12. Next slide. The next slide is the cases for, is a summary of the cases for head office. And then for head office, when you look at construction, the construction cases that are registered for head office are about 26 active litigation cases on the database for construction, and total value thereof is 442,699,422 rand 99 cents. Now, the volume, Chair, of the nature and size of the projects that are managed at head office, they are huge. They are what we call special and major pros. So that's why the volume of the claims as well as the number. Now, in the leasing area, there are only about 8 active litigation cases held at head office, and the total value of the claim is 90,439,000. Head office has got minimal because it's not directly managing the leasing, but there are those matters that are of strategic importance. We are supporting certain regions on them. That's why we have about 8. Now, on the area of facilities and land-related litigation, we have about 17 active litigation cases registered on the database at head office level. The total value thereof is about 533,393,457 rand 1 cent. Next slide. Let's go. Next slide. We need to go to duty of care. Yes. Now, the duty of care related claims at head office, we have about 3 litigation matters that are still active on the database with good merits in favor of DPWI in all those claims. Now, we have a solid defense in all of them. The value thereof is about 18,454,078 rand 85 cents. Now, one category of claims, to say defamation of character claim. In this one, the plaintiff sued the department for publication of a media statements by DPWI on matters relating to investigations of fraud and corruption report. Now, the claim has been defended on the basis that the statement is true and said in the public interest. The plaintiff has since lost interest, is not pursuing the matter anymore. The total value of the claim was about 10 million and is now dormant. Next slide. Now, the summary of head office of finalized cases. Head office, we have finalized about 21 litigation cases, which have been removed from the litigation workbook. And the description of all those matters are there with their details. Next slide. Now, if you look down there, the total number of dormant matters at head office level is about 32 cases, and total number of litigation matters on the register is 92. Next slide. Now, we are dealing on this next slide, we're just dealing with high level on the causes of what are the causes of dormant litigation matters. Mainly, there are total 39 dormant matters on the regional offices workbook that has been registered, and total of 32 at head office, which takes us to about 71 dormant matters. Now, in some cases, plaintiffs lose interest after DPWI files a plea or an exception, and they no longer matter then do not advance. Now, the other issues around capacity constraints, the Office of the State Attorney to pursue and finalize cases while they are still fresh. Understanding that they have got a lot of cases. Sometimes they say, but let's leave it lie because it's not an urgent issue. Now, they don't have capacity. They are faced with number of cases, mainly from SAPS, Health, and Home Affairs. So sometimes they adopt this, and we continue to engage to say, but let's find a way in which we can push these matters and finalize them once and for all. Now, the other area is where DPW has good merits, but unfortunately, there are no witnesses available. Some may have retired, some have resigned, and they are not willing to assist the DPW after employment. So it would be because you would not have witnesses to lead your evidence. Now, in other cases, we have instances where plaintiff companies have been deregistered by CIPC, And in terms of our law, once a company is deregistered, it ceases to exist as a legal person. Now, we may not even proceed to sue it until it is restored. Its legal personality is restored by way of a court order, or it's re-registered. The other area as well, plaintiff stalling action. And the merits, you will find that they are 50-50. The case may go either way. Then on the advice of state attorney and counsel would say, but look, the case, we are not clear. Maybe let's allow it to pend and to die its natural course. However, that approach is fine at court level, but for auditing and accounting purposes, it's not moving. It is still a contingent liability and so on. Now, what are the next slide? Let's look, we're looking at the measures to address the dormant litigation matters. Now, as part of those measures, we have obtained a legal opinion through state attorney to look at ways and means in which we can try to finalize all these dormant cases. And the opinion recommended a case-by-case analysis of each matter. Hence, there was a need for the legal services, working, of course, with the minister and the DM to then review the entire workbook and make clear recommendations on which matters we should be able to send to state attorney. Now we have generated a submission to the accounting officer to approve that we approach state attorney to appoint one counsel who can then review, independent counsel who can then review the entire workbook and make substantive recommendations to finalize these cases. And we're informed that the approval by DG has been made on the 11th of August, 2022. We're waiting for that feedback. Legal Service Unit further wishes to recommend that the state attorney should consider other approaches, such as also approaching the plaintiffs and or applicants' attorneys with a view to say, on those matters that are dormant, that are not willing to take forward, perhaps we settle on the basis of each party paying their own legal costs, because at most, they are not willing to withdraw on their own, knowing very well that there are cost implications, because they will have to tender cost to the state. Now, that's one area that we need to explore. We further also wanted to consider convening a session with the Solicitor General to explore other ways and means to capacitate state attorney offices. We have realized that state attorney offices such as the Nelspruit one, at some stages it was operating with only 2 legal practitioners, and the work there is too huge. They need to check up that, so that at least if the attorneys there additional capacity, they would be able to pay more attention to the dormant cases as well. Next slide. Before that, let's go back to the other slide, because there was one issue that we have also recommended. Yes, as part of the engagement on these matters with the minister and deputy minister, there was we have realized as well that there's a need to intensify the use of alternative dispute resolution mechanisms. As the department, we have made inroads in that area, because most of the disputes in construction, your facility management related issues, they are not purely technical, they're not purely legal issues. So they are mostly technical issues, and they are best dealt with through appointment of expert mediator in the subject matter. And we managed to finalize some of those claims. Now, this is one area we can use, especially on these technical and related claims. Thank you. Next slide. The next slide, this one, we're dealing with the expenditure, is the expenditure analysis report. As at 30 July, Chair, the expenditure for the legal services in terms of recovery to state attorney was about 9,598,379, which has since been processed to Department of Justice for state attorney offices. This is the service that they render for all these regions. And the total allocated budget for this financial year was around 19. And the expenditure is a bit high, given the fact that we're still in the second quarter. However, most of the invoices that were processed, they were involving transactions or commitments which were made in the previous financial years, which has an impact on the new budget. Now, some of the cost drivers are mainly in the following areas. The disciplinary inquiries, of course, are arising out of the investigative reports, which are now being implemented by legal services. That is your Public Service Commission report on irregular appointments, funeral reports, and the Bait Bridge border post. They are as well contributing towards the higher expenditure. Then general litigation claims. These are the claims we're reporting on today. Then we have arbitration matters where legal representation is permitted by commissioners. Then labor relations would seek for our assistance in terms of appointing counsel through state attorney. And also the other cause is also the involvement of the drafters on our 3 bills as well. We have to, from time to time, outsource the services of counsel. That as well also contribute. Now, the last issue is around the containment measures. You will note, Chair, that during the COVID-19 period, we could not outrightly apply for eviction orders. We had to get interdicts and then put containment measures. Those measures, they also come with costs because so far, I think we've paid the sheriff around 2.5 million. That as well drives the cost. Now, next slide. Now, in conclusion, this is just to summarize everything, to say at regional office level, cases as at March 2022, regions account for 223 litigation cases, and total number of head office litigation cases as at March for head office is around 92, and then total number of dormant litigation cases on the register for both regions and the head office is 71. Now, total number of closed or finalized litigation cases on the register as at March 2022 is 38. Now, total number of litigation cases on the register as at March 2022. In total, what we're having is around 315, and the total number of cases remaining on the register, when you take out the closed matters, it took us to 277. Now, for April and to June, which is Q1, which we are still assessing, we have about 22 new matters. And then it takes the total to 299. That's all. And my apology, Chair, the presentation does not seem to be very well aligned. And I've discussed with a colleague from ministry, but unfortunately it was already submitted. I think when they were doing quality assurance, some of the slides moves. That's why the alignment. I need to apologize to you and the members. Thank you. Thank you, Chair.
Any words, Minister?
Yes, thank you, Honorable Chairperson. Just to add, Chairperson, in consultation with the Auditor General of South Africa and the finding that month-to-month leases amounts to irregular expenditure, we brought all month-to-month leases to an end in December of 2021, where we gave notice that there will be no longer month-to-month. The progress that we are making out of 1,817 month-to-month leases, we have reduced that to 122 under the leadership of Dr. Alec Moemi, who's really put in better systems. And through the renegotiation of the overcharges by the private landlords, we have been able to save now more than 273 million that has been recovered, and the process is ongoing. We are now, I have requested that we put a system in place whereby all invoices for leases must be posted on a single entry point, so that all of us can see the amounts due to the landlords, and thereby avoiding overpayment or avoiding unauthorized payment to certain landlords. And we certainly hope that with the new system, we will be able to curb all the litigation around month-to-month leases especially. It was a big fight, but the landlords have come to accept now that we are no longer going to pay on a month-to-month basis because it is irregular expenditure. We have further grouped the 10 big landlords together, and we've established a team to engage with the 10 big ones. And we're making great progress there to solve some of the disputes around payments, and the system is working very well. Because out of the 5 billion rand that we spend every year on letting in on behalf of government departments, the 10 landlords in the country accounts for about 80% of those leases. So those are the systems that we've put in place. I can confirm also, Chairperson, that the senior counsel has been approved by the state attorney. It was signed off by the DG, and I also signed it off last week. And we expect the senior counsel to start on the 1st of September, who will then carry out the instruction of the state attorney that we do an analysis of all the cases. And I think by the end of the year, or maybe sooner, we can come back to the portfolio committee with that analysis of cases. Because we also have to see, Chairperson, in all of these litigation cases, where in fact there was a judgment in favor of a Dpwi and cost awarded against the applicants, that we also recovered that cost. So this new person that will start on the 1st of September will certainly assist us to deal with all of these dormant old litigation cases that's been in the system, some since 2013. So that is the new system that we put in place, Chairperson, and I hope that will be able to assist us to reduce the number of litigation on especially the leases. I thank you.
Thank you, Minister, and thank you to your team for the presentations, the first one by Mr. Lwazi and the second one by Mr. Christopher. I now invite honorable members to deliberate and discuss on the two presentations. Honorable Shabalala will be the first one. Honorable Graham Murray, the second one. Honorable Hicklin, number 3. Honorable Tring, number 4. Honorable Van Skalbeek, number 5. In that order, please. Honorable Shabalala. Honorable.
Thank you, Chairperson. My apologies. I will talk and run to the project around my area. There's an MEC around. I wish to appreciate the presentation by the department and also indicate the issue of good governance and capable state. I think it's only fair to support that there needs to be filling of the post around the area that will strengthen the good governance. Safe to say, Chairperson, that I think good governance goes hand in hand with what could make an impact to the community. For instance, we cannot neglect the issue of job creation. I don't know how one can emphasize on this one except to become a broken record. The issue of insourcing some of the workforce like other municipalities have done. I can make an example in Ladysmith. Instead of giving all the security jobs to private companies, there is an army of security guards that have employed by the municipalities. That is one other example, because when we sit in a meeting, we need to go out of our meeting and say we have this will make an impact to our community, to an ordinary citizen on the street. Coming to the issue of litigation, winnable case and not winnable case, I think we have had the statistical presentation. It's technical. It's having statistics and without narrative. Maybe, Chairperson, I wonder if this meeting could have been a closed meeting, because as the committee, I don't think it's fair to us to give us that there was a case, there is the cases, we don't even know what was the reason, we don't even know. I know for a fact, Chairperson, because when I had an office in Manzimtoti some years ago, I had two cases that came to my attention. It was the cases against, I don't know whether it was court cases, but it was the grievance against IDT in Durban at that time. I also remember that one of the cases landed in court. And I know for a fact that to date, although the other one, I lost contact because I left Durban, so I may not necessarily have the update, but I know that the other case was dragging on and on for some years. That's why we have something called dormant, because some of the people could not be strong enough financially against what the capacity of the state to sue the state and stand in court with the state takes the guts. But let us put face and narrative, even if we don't put the face. But I know that there are faces around the issue of litigation against the state. One of the things, Chairperson, is that we are not. I don't get the information around the private firm that are being that have been appointed, and how much was paid to the private firms. I know for a fact that there are private firms that have been appointed, that have been in and out of court, and on behalf of the the department, despite the state attorney. So we don't get all this information. I'm sorry, Chairperson, because we have a constituency office, some of the things we get to know them, but it will be worse if we get the information from outside in the newspaper or on the street without us as members having been taken into confidence around these issues. I want to end there, Chairperson. Thank you very much, and thanks.
Thank you, Honorable Shabalala. Honorable Graham Murray.
Good morning, Chair, and good morning to everybody, and thank you very much for the presentations. It's very nice to be back at Parliament and working again in our portfolio. I did miss seeing everybody. Just on the Minister's closing remarks on the month-to-month leases, I just want to say that one of the places that I did oversight is offices that are rented by correctional services in Port Elizabeth. And when I got a response to my question on what had happened with the month-to-month leases, that property has been, the lease has been renewed for 3 years. But then somebody else asked a question, and then I asked a question of the Justice Minister about that specific property, and he advised that they're moving out in March 2023. So I'll send the details to the Minister's office, but I think that's something that needs to be looked at, because if we're paying for another 2 years, that's exactly how client departments move out before the end of a lease. Because there hasn't been proper communication between the two departments. So I will follow up with the Minister's office on that. With respect to the first presentation, I think it's great that we're looking at this unit. My concern is that we're creating a whole branch to oversee what should ordinarily be the work of upper management. In other words, are we making sure that our managers, our directors, our assistant directors, our deputy directors are all capacitated to ensure that the work being done is being done properly? And are there checks and balances in place in those departments to make sure that there's compliance? If that were the case, we wouldn't then need an entire unit to be monitoring governance, risk, and compliance if it was being done properly at source. My concern is that we've now got a unit that has got 5 deputy directors, 2 directors, 2 chief directors, and 6 assistant directors. Now, I don't know whether or not, and there doesn't seem to be very many people who are actually doing any work. So we're paying over 12 million rand per annum on those, 15 positions. And are those, I don't understand why we need so many directors when this is about ensuring compliance with normal procedures and normal operational requirements. So I'm very concerned that this is super top heavy, very expensive, and that there won't actually be actual work done, because these should be directed positions, should be decision makers as opposed to actual workers, and they should be the strategic people and not the people doing the work. So who's actually going to do the work of implementing this new system and making sure that this charter is properly implemented? So I'm just a little bit concerned that that whole unit is completely top heavy and not being properly capacitated to do potentially what is needed. And where we could actually be ensuring that managers, supervisors, and staff are properly trained so that they know what the requirements are in terms of governance, risk, and compliance. And then also, I mean, there's always these new policies, new strategies. They speak to this policy, they speak to that strategy. Has anybody actually really done a synopsis to establish exactly where the issues lie so that it can be a targeted approach as opposed to a global umbrella approach to this whole thing? I feel like we're sort of trying to address a major wound without looking at what the causes are of the injury that initially created this wound. There are lots of issues all over. We know the regional offices, as an example, are a huge problem because there doesn't seem to be proper management at those levels. So if we know that that's where the issues lie, then that's how we should be addressing it. Is just my personal opinion. And then with regard to the second presentation, one of the things I wanted to ask is, what often happens is there are disciplinary hearings against people, there are labor issues and that, and a lot of times when people are guilty, they resign before the matter is finalized. Is the department keeping records of those to make sure that should that person apply again for a position, I've actually spoken to colleagues to say that what we should be doing is lobbying the PSA to say to them, listen, you need to keep a central database of unresolved disciplinary matters so that when people resign to avoid a disciplinary action and they go and work at another department, there's a record somewhere of what led to their resignation. Because I think we're seeing a recycling of people who are corrupt, who are useless at their jobs, who are failing, who are walking out before they have a chance to be disciplined, and then they just go and apply somewhere else and they get another position with similar requirements, and they're then allowed to behave the way they do. So I think that's very, very important. Where a case has a poor chance of success as well, are those details retained? And is there a period after which that information is destroyed? With respect to dormant claims, do they ever just prescribe automatically? I know that where you have a claim for payment and that there is no prescription on those. But there must be a point at which we can say, okay, it's enough already. There were two, I think, that were mentioned where they were closed at the instruction of the state attorney. And is that all that is required to move a dormant case to closed? And my concern also, and I think Honorable Shabalala raised the same sort of thing in a different way, is that does the Dpwi intentionally drag its feet on cases where you've got small, medium, micro enterprises or companies that can't potentially afford long durations of litigation, and that potentially can't do other work because they're dealing with issues around DPWI, and as a result, I heard about a company in the Eastern Cape. It's a Department of Public Works, Education, etc., but it's not national. But I'm just giving you an example. They are owed 80 million rand. They won a court case to say that they must be paid that 80 million rand. They're closing shop next week because they haven't been paid the money and they cannot continue to carry that business. So, I mean, a company that's earning 80 million rand has got a lot of employees. They're creating a lot of jobs and they're being forced to close their doors because government is not complying with legal prescripts. So I just need us to be assured that DPWI is not doing the same thing and not dragging its heels so that smaller companies who don't have the force of government and have to carry their own legal costs are not closing or being forced to close their doors because they cannot afford the litigation. And then I wanted to ask about the litigation fees, but I see 90 million is budgeted. So far 9.6 million has been spent with the state attorney. I'd like to know how much has been spent on private attorneys, because I know, for example, with various issues, sometimes we do have to use private attorneys. Also, is there a mechanism in place where litigation arises out of a decision made by an official, where those officials are being held accountable for any litigation and potential costs incurred? Slide 28, 14.3 was speaking about how we're going to be addressing dormant cases, and one of the things it said was, or the causes of the dormant cases, it said the state attorney's office is under-resourced, and as a result, they're not reacting fast enough. How does it, again, that affects the other party, because if we're not coming to the party with a case and we're dragging our heels, they're sitting waiting for litigation to happen. They can't move forward. They can't address it. And the issue lies with government. So I think that's something that really has to be addressed. And then finally, with respect to alternative dispute mechanisms, I think that's a brilliant idea. I think it's definitely something that should be done because of the cost savings. Is DPWI, is there capacity within the department to have dispute mechanisms or alternative dispute mechanisms, and how will that look going forward? Because I think there were a couple that have already been resolved in that way, and I think it's an excellent way of dealing with the more minor, or as you said, the more technical issues. And then I think the minister answered my question with respect to in-house senior counsel. So I was going to ask about whether or not it would not make sense to have somebody who can look into that, but I think the minister's addressed that. So thank you very much. I appreciate the opportunity.
Thank you, Honorable Graham. Honorable Hicklin.
Thank you, Chair. I just need to kill somebody's phone in my office. If you'll hold on, please. I cannot switch this phone off. Sorry, apologies. There is another phone ringing in my office. Thank you so much for the presentations. Much like Honourable Graham Murray, I was just coming from this exceptionally top-heavy structure that we're trying to bring into place. And as Honourable Graham Murray said, are we capacitating the departments itself and the people within the departments to actually make the decisions without having to bring in this really top-heavy structure of directors, deputy directors and the like? And then asking the question of who is going to approve these appointments? Who are they ultimately going to be reporting to when the work could be done by the people who are actually within the DPWI itself? And then asking the question, what are the chances of recovering the funds from those who have resigned before a disciplinary hearing has been taken place, instead of going to a civil suit? Is there any chance of recovering any of those monies? And we know what it's like when people know that the chips are actually down and they're going to face a very strong civil suit that is going to come down on them, and they resign prior to the hearing actually falling and the axe falling on their neck. How do we get the money out of them? Is there any way in which we can pursue that? We need to really make it a business of filling vacant posts within a department so that we don't have to have these gaping holes within a department that leave us open to a leadership vacuum, a vacuum within a department such as we are facing within the DPWI. Moving on to the PMTE presentation. Minister, I'm afraid I'm going to have to quote your own words to you that you made in a statement to Biz News on the 16th of August, in which you said, "I'm sorry, but my ministry is in chaos." This presentation on the PMTE actually says exactly that. We have so much or so many cases of mismanagement, of litigation, of claims, whichever way you want to look at it. And we have to look at the DPWI actually reducing those number of claims, whether they are dormant claims, whether they are claims of good merit or bad merit against the DPWI. We have to tighten the measures within the department so that these claims don't make it into the public domain, so that we don't have situations where we have companies being able to get out of leases without walking away before the lease is actually due, people walking away without actually fulfilling their mandate to the DPWI. I have said it before, the PMTE, the portfolio, the management agents, the management entity, version to making money. We have to go back to being a trading entity. We have to capacitate our directors and management into becoming a business. And that is solely within the purvey is our own entity. It's in our own hands. We have to capacitate the department to becoming a trading entity again. We are not a trading entity. We don't operate, the DPWI does not operate as a business. We have to make the department capacitated to operate like a business. We can't have month-to-month leases. We can't create loopholes for ourselves that we and fall into our own traps, as it were. I really like the alternative dispute resolution mechanisms. I think it's a fantastic way to go, as opposed to going to expensive litigation, both for the Department of Public Works and for the small man in the street who cannot afford the litigation and so gets caught in the trap like Honourable Graham Murray has suggested, where government eventually admits to owing people 80 million rand, and then they have to close their doors because government actually hasn't paid and met their obligation. I think I'll leave it there. Thank you very much, Chair. But we just need to make sure that we become a property management trading entity and not just a managing agent. Thank you so much, Chair, and thank you, Minister.
Thank you, Honourable Hicklin, Honourable Trink. I've seen your hand, Honourable Suisa. You will follow Honourable Van Schalkwyk. Thank you.
Thank you, Chair, and greetings to colleagues and the ministers. The minister is present. Chair, I think just a few questions. Firstly, with regards to, I'm going to start with the slide on the department and the PMTE. Firstly, thank you also for the presentation and the inputs that we've received. The slide 5 of the presentation speaks to a claim of some 107,005.98 rand for a claim for goods and services that was rendered by someone who was employed by the state. Chair, I think I find it difficult that, and even though 107,000 rand for some may not be a large amount, but still it's an indication that things are slipping between the cracks, because this should not happen. I think that we have sufficient legislation, your Public Finance Management Acts, your Supply Chain Management Acts, and so on, amongst others, prohibits employees of the state from doing business with the state. And so, I want to find out how is it that the checks and balances that should be there are not put in place to prevent these claims from actually happening. And then slide 14 of the presentation, it indicates that in Port Elizabeth, the duty of care related to the claim of some 339 million rand. There was one claim with poor merits against the department. So my question is, of that total of the 339 million, what is the value of the one claim? Is it 200 million? Is it 100 million? Is it 5 million? Because that's a huge portion of the 300. And I thought I heard the presenter indicating that it was a large claim. So what is the value of that claim? Slide 14. My third question then is with regards to the total value of claims. I'm not sure, and I may have missed it, but what is the total value of claims with poor merits? Claims with not just all of the claims with good and poor merits against it, but the total number of claims with poor merits against the department. That will give us an idea of what we need to be preparing to pay if the case that has been leveled against the department is seen to be one that is winnable, and what is the value of those particular claims. And then perhaps in line with that, how many of the claims are actually from our sister departments, and what measures are in place also to kind of mitigate, with claims coming from sister departments. And then what plan is in place to ensure that we have a proactive maintenance plan, a proactive, not reactive, not when we get claims, now we want to start fixing things, but a proactive maintenance plan for all of our buildings and properties under the department's care. In line with that, I have a complaint from a businessman in Port Elizabeth who, and maybe I'll take this up with the minister outside of the meeting, but property that used to be properly maintained by Public Works, they've stopped maintaining it apparently because within the province they've indicated that there's no more funds. The businessman used his own finance to clean the properties, a few hectares large, but he's now indicated that he can't continue. Financially, it's just not possible for him to do what Public Works should be doing. So this is an example of proper maintenance, proactive maintenance plans for the property as well as the buildings that we have. I want to agree with Honorable Hickling. And I think that it's important that we realize that public works has one of the largest property portfolios in the country. And we have in the private sector, companies that have a minutia of properties that are roaring businesses. And clearly we've got to use the business principles to begin to turn particularly PMTE around. And then finally, Chair, while I support in principle the establishment of the Ethics and Compliance Unit, it cannot be a unit that is all bark and no bite. I think we have many excellent policies and crime-fighting units in South Africa, but I think we know all too well that when these units become captured, whether by political, private, public sectors, then these units fail to conduct their work without bias, fear, prejudice, or favor. And I think that this unit cannot fall into that category. Thank you, Chair.
Thank you, Honorable Hickling. Honorable Van Schalkwyk.
Thank you very much, Chair.
Yes, Honorable Thring, Chair.
Apologies, Honorable Thring. Sincere apologies. Sincere apologies.
Understand. It's been a long while, Chair.
Honorable Van Schalkwyk.
Thank you very much, Chairperson. It is indeed great to be back. Yesterday I was missed, and today Honorable Thring is Mr. Hickling. But it's good being back, Chairperson, and greetings to Honorable Minister, Chairperson, our work, Honorable members, and the departmental officials. Thank you very much for the elaborate presentations. And Chairperson, I'm not going to repeat the questions that have already been covered with in terms of the previous members. So I'll start, Chairperson, in terms of the PMTE, in terms of the newly reconfigured Ethics and Compliance Unit. I think it's an excellent idea, and I hope that the new measures that they are putting in place will indeed bear positive fruits. I'm just concerned, Chairperson, in terms of the civil recovery of the more than 1.4 billion rand. And I need to know, they've put in place some measures, but what extensive measures do they have in place to ensure that they indeed recover majority of those amounts that of the 1.4 billion rand? Then, Chairperson, I'm very worried in terms of the vacant funded posts that's not been filled. And many of them are in terms of prolonged period for more than a year. Whilst we are having a huge unemployment in our country. So my question would be, what are they doing in terms of filling those posts? And can they give us an indication if that is scarce skills posts, or what is the nature of those posts, and what is the reason that they are not filling it in time? Then I need some clarity, Chairperson, in terms of how long does it take to declare a claim dormant? Because it's good and well if the claims are being declared dormant, but I'm just wondering, in the event that those claimants come back at a certain stage, and specifically claims that doesn't look good for the department, how is the department going to deal with those claimants if they come back after a specific period? Then, Chairperson, in terms of the construction-related claims, I'm very interested in terms of knowing which grades the service providers are on the CIDB contractor register, and how many of these claimants are appearing multiple times. Then, Chairperson, I noticed the low number of finalized claims, especially in terms of regional offices. So I want to know what the department is doing in terms of assisting them to finalize those claims. Then a big concern to me, Chairperson, is the monetary value attached to this outstanding claims. It's a very high amount, and I want to know if cases are finalized, especially those not in favor of the department, is the department financially able to pay these claims, or what is going to be their plan B in terms of the budget to finalize those claims? Then in terms of the alternative dispute resolution mechanisms, I'm really in favor of that and commending the department for that. And I think I'll pause there. Thank you very much for the opportunity, Chairperson.
Thank you, Honorable Van Schalkwyk. Honorable Suisa.
Thank you, Chair. Greetings to everyone. It's good to see everyone. Chair, I've been following the presentation that has been done. I went through it yesterday, and I'm a bit concerned. I'm going to make an example of a breach of contract whereby it said that the file is lost, and the first registration was in 2007, the next one is in 2015. I think it's, if I'm not mistaken, it's in Mabatu regional office, which means that we'll never be able to recover whatever that needs to be recovered because there is no file. And the reason that files get lost is because of it takes so long for things to be finalized. And I asked myself, is this the only regional office where a file got lost in the process? And then when you look at the summary of all these litigations and everything that's happening, in total there are 315. Out of the 315, only 38 have been finalized. Out of the 315, dormant are 71, which means that we have an outstanding of 227, which I don't know when they are going to be finalized. Some cases go back as far as 2007, and they are still not being finalized. This raises questions that it seems as if the department itself does not have the capacity to deal with all these litigations that are happening, and it means that they are going to run at a loss. Now, one would ask, who are the contractors or these people that we are leasing from or we are leasing to, if we can be provided? Because yesterday I was watching an interview on SABC whereby the people of Val were complaining about incomplete projects in the Val, which is Citybang region in Gauteng province. There are a number of projects that are incomplete, and the MEC was trying to explain, but I couldn't understand actually what is she trying to explain. There are schools that are incomplete, there are stadiums that are incomplete, and there's one company which is at grade 9 with the fear that this company is dealing almost across South Africa in most of the projects, which at some point, if we are having projects that are incomplete, then later on, there's going to be litigations to say that one way or the other, this company needs to pay us back. It comes back to say, how far is the process of actually finalizing the blacklisting of some of these companies? Because if we go at what this rate, we are going to reach 2030 or 2059. And we are still going to have outstanding litigations that have never been finalized. And it means that the department is running at a loss. It's either they are not getting their money, or at some point they have to pay people because of non-compliance and everything. I was also listening to the presentation where they spoke about the GRC that was established in 2017. but still the same GRC was not fully capacitated to deal with governance, compliance, and ethics. And I ask myself, the new framework that is there, is it going to deal with governance, compliance, and ethics effectively so? It shouldn't just be something that is written on a paper. Are they going to be able to deal with compliance and ethics? And what do we mean? What does poor merits mean? And I think one of the honorable members, I asked the question to say, poor merits against the department or poor merits against the people that, because there are cases where it said that there are poor merits against the department. What are the poor merits that they are talking about in that? And then the dormant, the dormant, I'm worried about this dormant claims that are there that haven't been finalized, because it's going to go on. If there are cases as back as 2007, they haven't been finalized, and we are in 2022, one would ask yourself, will they ever be finalized? And I think Honorable Hickling touched on what steps are going to be taken against people who resign while there are cases against them, and then people just decide to go, and then it's also going to lead to a loss. But Chairperson, I'm very worried at the number of cases, and I know by the end of the financial year next year there will be other cases, because this report is to date of March 2022. What's going to happen next year? They are going to increase. As long as we are sitting with a department that hasn't finalized any other outstanding claims or cases with them, then it's going to be, because we need to be taken into confidence as to whose fault is it. Is it the fault of compliance from the department, or the fault because the department needs to take everybody into confidence and take everybody through the steps to say, this is the correct procedure that you need to follow. Then we won't be having so much cases that are out there. I would share the same sentiments with Honorable Graham Murray to say that the department is failing some of these contractors or some of these people because they rely on the money that comes from the department, but for some reason they end up not being not functional because of they're still waiting for money to be paid. Some of them, there are even reports to say that some of these companies, they've lost interest. That's one of the reasons why the contract, the cases become dormant. They lose interest because the department is not coming on board. And if public works can't make everything to work, then we are going to have a problem. Like the problem that, for an example, that I've spoken about of the VAL, where there are projects that are incomplete and the reasons that have been given just don't make sense to me. So on that note, Chair, that's my only input for now. Maybe I'll make an input after the responses. Thank you.
Thank you, Honorable Siwisa. Again, let me appreciate the presentations made by the department on the two issues that we have requested for today's meeting. My questions or comments on this. I agree with all the members that are saying that the unit it's very important and necessary. But my question is that as the unit is also to ensure compliance with the PFMA, are they reporting according to the timelines of the PFMA? If so, why then are there no improvements in terms of audit outcomes? Two, I also echo what my colleagues have said on the issue of vacant funded posts. I think, as we all know, I heard though that the rate for unemployment has decreased a little. I don't know whether it's 0.6%. And to me, that 0.6% doesn't mean anything if you look at what is currently happening in South Africa. So if we continue having funded posts that are not yet filled, we are also contributing to the high unemployment rate that is out there. And then on the second presentation, I also support my colleagues on the issue of the so-called dormant cases. One of the things that the COVID has done, other than killing our brothers, sisters, mothers, aunts, and so on, it also took people out of business, especially the SMMEs. So on this case, is it not the case that that business had to let that case lie there because it has nothing? It doesn't have money to follow the case up. So are we not maybe having such challenges in those dormant cases? And again, are we not having such challenges in the cases that we are saying the department may win, as we say that the department has merit for that? Lastly, on the issue of these cases, I think I appreciate I think it was the minister saying that they plan on having a multi-pronged or whatever strategy, so that you deal with the case even before it goes to a point of litigation. I think that would be good, especially for those struggling SMMEs or contractors who are part of this. But also, we must have a register that shows, I don't know whether CIBT is doing that, those that have defaulted, maybe a certain contractor was doing a certain project and then it defaulted and the project is not finished. Then following that, I think we need to have such registers of the defaulters, because you'll find out someone has messed in public works, that person goes to work in Department of Defense, also messes up. So we need to see such things so that those are seen as defaulters and they are not given maybe work in other departments. Thank you again, Minister, and your team. Over to you for the responses.
Thank you, Honourable Chair and Honourable Members, and thank you for all the responses. Chairperson, I do see it's clear that we have to come back to the committee with a lot more details. The point raised by Honourable Shabalala about putting a face to some of the cases, I agree, because once a case is in the court, is in the public domain, and certainly we can do like a synopsis of every case that is in court with the name of the applicant, the name of the respondents, because it is public knowledge. It is just that we've not included in this presentation. Also, the list of private firms appointed by the state attorney and the value of that, we will have to source that information from the office of the state attorney. Chairperson, I also appreciate the oversight visit by Honourable Graham Murray and Honourable Tring, and I will request that they send both those queries directly to my office so that we can give them some answers to go and give feedback to their constituencies. Just another point, Chairperson, in terms of this unit, which was approved by the Department of Public Service and Administration in 2016. As Public Works, because government work on a basis that all departments are designed the same, like one size fits all. The point raised by Honorable Graham Murray also. And you've got this hierarchy in the organogram. We are only allowed, as we speak now, to appoint from the approved structure of DPSA. If we want to change the structure and we want to add new posts to the structure, we have to go back to DPSA and seek their permission to add any additional posts. So what we have now since 2016, that is where we need to fill those posts in an approved structure, because we cannot do otherwise. And that is why I have proposed that all the slippage of the funded posts that we have, that money be transferred to the unit to fill those posts before the end of the year. So we are monitoring the situation. I want to thank Honorable Hickland for the support on the month-to-month leases. It is not being an easy journey, but we are getting there slowly. The private landlords got the message that this is the future. And the other general comment, what I wanted to respond to, it is possible to put together out of the litigation cases, all of the cases where we have got a poor chance of being successful. Because sometimes also, and this I've been thinking about for a long time, is that, you know, sometimes we just defend cases for the sake of defending because we don't pay for litigation. So with the alternative dispute resolution, we will invoke that before we take a decision to defend a case that we know that we are not going to win. So the alternative dispute resolutions will assist us a lot also to reduce the number of cases and litigation against the department. Then the vacant funded posts I've dealt with. And then the other point that I wanted to just make a general comment on is the, in terms of the PMTE. The PMTE has never achieved the envisaged outcomes for what it was established way back in 2014. It was established with the intention that the property management trading entity actually brings some income into government. Instead, what has happened since that time is a perpetual qualified audits and an overdraft banking account of 1.3 billion rand. And that is why the first attempt to begin to get some income for the PMTE is the project that we will be briefing the portfolio committee on, I think, next week or this week, which is what we have now done with the new policy as a refurbish, operate and transfer together with the private sector. That is one of the issues or the strategies that we have now put in place to deal with the poor maintenance by government on government buildings and bring in the help of the private private sector to help us there. I have, and we can present the report to the portfolio committee. When Dr. Alec Moemi was appointed as the head of PMTE, we had requested that he look into and doing a complete assessment of what this PMTE is supposed to be doing, that they are not doing. Secondly, what are the options of how we can transform the PMTE so that we bring it back to what the intention was in 2016 when it was formed. And he has produced various options. And so as we are now restructuring or reorganizing the PMTE, we spend a lot of time just sorting out the leases, and as I've reported, we still have 122 leases on a month-to-month basis. But the information that the members has requested, Chairperson, that once the senior council start work on the 1st of September, we will take all of the additions that the members would like to see in a report to the portfolio committee and ask the new person who is going to do an independent assessment of all the cases to include also the faces, the names of the cases, the companies, and all of the detail that the portfolio committee is requesting. Just Honorable Hickland, I spoke to Martin Well last week when I was in the middle of nowhere in a rural area. And he phoned me about the portfolio committee on police. And I confirmed to him that when we appeared before the portfolio committee, that they were not very happy with the performance with the police portfolio. And in fact, subsequent to that, we have put a joint committee between the police and ourselves together. And we are waiting on the portfolio committee to call us again so that we can give them feedback. But I'll also provide the report to Honorable Hickland. Thank you, Chairperson. Chairperson, just one more thing. I wanted to be excused just for 15 to 20 minutes, just to make a presentation to the Cabinet Committee on EPWP policy. They have agreed and excused me for the rest of the meeting, but I have to introduce the EPWP policy. So I just want to ask your indulgence for 15 minutes for the most. Then I will just step out of the meeting and then I will come back. Thank you, Chairperson.
Thank you, Minister. We will then allow you to do that. Come back if our meeting is still on. We'll then let your team to respond on some of the comments and questions raised by members.
Oh, through you, Chair, if I may.
Yes, please do so.
Yes, thank you, Chair and members. And also for the comments and questions. I think Minister has covered quite a lot on the part of the establishment of GRC and the budget and priorities. And I think the one point that I wanted to bring also, I think there was a question around whether this will be effective, and also in line with another question that's raised, why this should be done by management. Let me start with the effectiveness. One of the areas where we have started this as well is that we've just concluded phase 1 of the lifestyle audits, which working together with the SIU and linked to the DPSA. So that is the one aspect of one measure of effectiveness of this, and with time, this unit will also be giving effect to all of those issues as well, and that contributes to your compliance, ethics, and code of conduct in the public sector. Now, using that as an example of why is this not part of a management function, and I think the one aspect of it is the independency of this is also a key aspect of it. One example, if I give, is that yes, management is a function to ensure that they have a code of conduct, ethical behavior, and all of those issues, and compliance to legislation and regulations. The one aspect that this unit is bringing to the organization is the overall level of assurance, regulation, supervision, with the requirements and restrictions and regulation in respect to governance and ethics and compliance. So you may find that on the one part, one line function or a management function may understand that they are well within the parameters of the law, but this unit then looks at the overall in terms of whether the management as well as line functions are well placed within the parameters of the law. The second aspect is that because there are significant changes in the environment, be it the regulations, the laws, etc., etc. So the unit is well alive to those changes, which from a management point of view or line function may not be privy to understanding even the technical aspect of those. So the unit will be bringing those changes as well in that. So one may maybe probably liken it to your financial services, financial sector, which used to be Financial Service Board in terms of regulating the financial industry. But you'll find that even within the individual banks and the financial institutions, they also had their own regulations. But overall, you will look at it in the context of the market regulation in relation to financial sector services. So this unit also serves that kind of approach in terms of the independence, assurance, regulation, and requirements overall within the institution, where the one impart knowledge, 2 monitor, 3 advise, and empower line management in relation to the changes that are happening in the. So that is the context as well in which this function or this unit will be looking into. Thanks, Chair.
Thank you, Chair. If I may come in.
Please continue, Chris, please.
Thank you. Chair, thank you. And on the issue of the litigation cases, the statistical information versus qualitative. Yes, of course, we agree with the sentiments by the minister that we may have to attach a face and a narration, and we will do that. But I also needed to indicate that the challenge is that as well, if you look at the presentation, actually it's a summary of a summary. We tried as much as possible to limit it, but it's difficult. Some of the information will go out critical. Now, on the issue of the private law firms, like the minister has also highlighted, yes, we will check, but just to indicate that as DPWI, we do not appoint private law firms directly. The private law firms can only be engaged through state attorney, because the state attorney is our attorney of choice, and where there's a criteria set for that as well, where they have a conflict of interest or they don't have in-house capacity to manage particular matter, or the complexity of a particular matter requiring a private law firm because of the nature of the issues, the matter involved, they are able to recommend that. Or where they require a correspondence in far-fetched remote area where they do not have an office, they usually engage the service of private law firms. So we'll get that. On top of my head, I'm aware of the 3 law firms which have been appointed through state attorney, but we will get the information and provide as well from state attorney. On the issue of disciplinary matters, record of unresolved disciplinary inquiries, from the engagements with labor, there's a record that is kept in governments once people do resign and leave while disciplinary hearings are pending. As soon as they join government, there's a process from the department to forward the charges and everything to the other department to say these were the pending charges. You will need to proceed with them. Once they rejoin, then they will be charged with that side. Remember, we do not actively manage disciplinaries. We were only delegated to deal with these 3 matters. But that information the full details thereof can be provided through labor relations in terms of a response, the nitty-gritties of how that process is managed. And on dormant claims, yes, we realized that this is a challenge as well. There are a number of questions around it to say whether dormant matters can prescribe how long, how do we determine that a matter is dormant? On average, when you look at it, if a matter does not move for a period of more than 12 months, the other parties not, it becomes dormant because there's no move, no further steps or anything. And that we can categorize it as dormant. Now, the issue of prescription, whether dormant matters can prescribe, no, in terms of the rules of the court, high court summons do not, once they are issued, they do not lapse. It's only at the magistrate courts where they lapse. So prescription, once the summons have been issued, has been interrupted, meaning the matter may remain for a very long time. Now, part and parcel of this review by the independent counsel who is engaged is to look around those matters as well and to make specific recommendations to the department and state attorney on creative means of finalizing these matters. And the impact, the other question is around the impact of closing those files in KZN by the recommendation of state attorney. There has been an engagement with the legal officer in the region and state attorney. Now, they look at the period within which the matter has been dormant with no movement. They decide to they shelve the file, actually. Now, in case further step, the matter is reinstated, is to take it out. Now, they are removing it from the litigation workbook to reduce the contingent liabilities. Because there's no movement, there's nothing, there's no progress that can be reported. But as soon as the file is not actually destroyed, the payment is shelved, in case the matter is reinstated, then they're taking it and then implement. Yes, of course, there's a risk involved. To say the more the dormant, the more people retire and so on. And the state would have to consider settling on unfavorable terms because there will be no witnesses, which is why we have indicated that there's a need to put a strategy. That's why this independent person with fresh mind to look at them and make those recommendations. On the issue of SMMEs who may be affected because of financial means, by not proceeding further with the matters. That has also been looked at now as part of the new system in the department. All service level agreements that we are vetting as legal services, we are now embedding the alternative dispute resolution clauses, mediation, arbitration, and so on, making it compulsory so that we can find ways to resolve these matters at a dispute level before they become litigious. Yes, most of the SMMEs are affected. Now, what happens with the new matters, 2020, 2021, we have been able to, because now mediation is compulsory in the High Court. Usually after receiving this summons, we ensure that we ask the other party to say, let's go for mediation and arbitration, because the aim and sole intention is also to establish whether the department has a clear, solid defense or there are some claims that are payable. And we can confirm that number of matters have been settled and relations were preserved through ADR system because it's user-friendly, least costly, and the environment is friendly, unlike in a court of law. We are able to find one another and build relations. Most of the claims we've been settling them through that process. Now, the challenge around the duty of care claims is in their nature, they are delictual. claims and liquidated. Now, once you settle the merits, still you have to deal with the issue of quantum. So the issue of quantum, it actually involves a lot of experts' reports and the nature of the injuries and the person as well. Now, it's not a clear, straightforward case that you can settle it quickly. For instance, if I'm an attorney like myself, if I get injured in a public building and only my leg, I suffer serious leg injuries. Now, when you quantify such damages, you need to take into account to say, for my business trade is what? I actually use the mind, and not necessarily the leg. When we consult, experts' reports have to be there. That's why matters of that nature, of duty of injuries, they still require some expert. They are not easy to settle them. There are guidelines to do that. Now, the other issue is the issue of responsibility of decision-making that results in the litigation matters. Now, usually in such matters, remember as litigation unit, we manage matters as they are contractually and what the issues are. Now, where we do see that there may have been a negligence, we do recommend that there be a further investigation. Working well with the GRC units, they will look into those issues. They go and investigate, look into the conduct, and then present the report to management. Then recommend different recommendations, either recovery or disciplinary as well. Now, that we also look into it. That's why quite a number of employees have been charged and they are undergoing the DC. Now, on the state attorney capacity, yes, in fact, they have a limited capacity to deal with dormant cases. That's why part of the responsibility of DPW and what the minister is recommending was to say, let's get this independent advocate who will then be able to assist in terms of reviewing these matters from state attorney angle and as well as the departmental level, engaging with us and the various line managers. Then we are going to determine whether the merits are in our favor. Where merits are not, then we find a way to settle. Where we have stronger measures is to say, how do we then get to these matters to court and finalize them? Because we can't wait for the plaintiffs. So in fact, this advocate will be providing that additional capacity to state attorney and the department. Now, on the other issue of employees doing business with the state, the case in point being the one in Johannesburg. Yes, that was an issue. We picked up the matter from our side when there were summons received. Apparently, there was a fallout between these partners. Then the other one blew the whistle to say, no, this person is actually employed. That's why the invoice was actually withheld by the RM acting proactively to say, I can't pay this invoice while I've got this information. And we have advised that the matter be referred for investigation to determine exactly where the person is involved. But in the meantime, we had to defend the matter. And we raised the plea to say that we are withholding this on the basis that we are not supposed to. Although if they were to come under a different cause of action of undue enrichment claim, maybe the court would have seen it other way. But contractually, we just said, no, there are issues with this, we are not supposed to. Now, the issue of slide 14, there's one claim, yes, for 211 million. This was as a result of the plaintiff actually is claiming that a fire originating from State Farm, which was not uncontrolled, there were no what we call fire breaks, then had to move uncontrollably to his farm and damage the entire property, sawmill and other things. The claim is 211. However, when the merits were assessed during investigation, it was found that it was improbable because the state farm was actually 15 kilometers away from this farm. And there's another farm in between. So it was not entirely possible. So at times, certain litigation, it is opportunistic to look for the state because obviously there's money there. But the facts clearly shows that no, it couldn't have been possible that the fire originates from State Farm and then jump the other farm and goes there. So that is the driver, the main driver of those claims, 211. And yes, on the issue of total value of claims with poor merits, we will need to do that because we summarized the presentation. In fact, the presentation, when you look at it, is too voluminous, and we try to limit it. There is another question of how many claims are arising from our sister departments. Most of the claims that are arising from Cape Town on those, for some of the farms, they are under custodianship of Sun Parks. Some properties are under custodianship of other client departments. But remember, when plaintiffs sue on duty of care, they have to join the owner and the user department. Now, the duty of care normally in terms of South African law, it places more heavier duty on the owner. Although we have got service level agreements interdepartmentally to say that these are our responsibilities, these are their responsibilities in terms of controlling access into their buildings and so on. DPW will be responsible for structural issues because those ones, they go with the ownership who are responsible for that. But still, if people comes in where cleaning services is under control of the sister department, people get injured when we did not put adequate signages and so on, they would still join the DPWI. Although DPWI is able to explain, if you check even in the media reports of the story which was running in PE, to say we have demonstrated also in terms of our service level agreements with the contractor to say you shall use the following material, which is not slippery in nature, you shall put signages. But the court still decided that no, by extension, the responsibilities of you, the owner, even if we can prove that the negligence was of the cleaning company and the lady there, clearly there's evidence pointing to that, but the court exercised different to say now the responsibility must go to public works. Now, in terms of duty of care claim, is difficult to defend it. But in our law, we know that you have to demonstrate reasonable steps that you would have taken to avoid. Now, over and above that, we asked to say, then what? There can't be a DPW official supervising every other magistrate court all the way and checking whether the cleaning services comply. But the court decided otherwise. Now, there has been an opinion to say, let's look at the issue, because the judge moved away a bit from how we understood the duty of care liability. Possibly we might look at that and the submission will be made to minister to say, are there grounds to appeal that judgment? On the issue of a structured maintenance plan for DPWI, from legal service point, it would be a bit difficult. Maybe this should be looked into, and then maybe facility management branch must look at it and then maybe present to the committee. We will take it out there. We might not be aware. The other issue, let me see. All right. On the issue of the file that has been lost in court in Mabatu, yeah, it's a concern because you don't know whether there's underhandedness and so on. But they do happen. We only experienced one, I think, recently, and the minister has to make some interventions at the labor court. The file disappeared, and we have had to reproduce another file departmentally from the pleadings we have. We put together a dummy file and submitted to state attorney and the registrar of the labor court. And the matter, we were able the court was able to hear the matter, although postpone it to September. And that was a concern, and she had to write the minister to the judge president in the labor court. So anything is possible nowadays. People run away, they will resort to all sorts of underhanded dealings. Now, one of those issues that we may need to look into as well, in terms of how you finalize, state attorney has to prepare a dummy file, engage the other side if they're there, check its file, and then go and reproduce another file dummy with the register. It's how the matter can be reinstated and then be finalized. The issue of who are the contractors used by Dpwi and their names. From a litigation point of view, we are able, it will be part of the report to say these are their names, these are the matters, but usually that information, the port where it resides will be the SCM. There is a central database where contractors are sourced. But for purpose of the litigation, we should be able to provide the names of those companies that were involved with in construction. But for general information, it would be the SCM that manages custodianship of that information. Incomplete projects, Chair. Yes, indeed, this is an issue, especially around there are a number of issues involved. There is an issue of poor performance. There is an issue of inexperienced contractors. Now you have to strike a balance because there are some school of thoughts that argue empowerment, and some say now if we just little poor performance and then we blacklist them, we finish them. So, but in terms of policy, from what we're doing is that poor performance, we usually terminate contracts and attempt to recover. We also have guarantees that we are able to recall. And but others now is to say there was some of the projects that are along in the system is where the department in the past was implementing these contractor development programs. You have some subcontractors who were appointed with a view to get trained and so on. Now the issue is how do we then strike a balance, because some could not perform, they're in a learning curve. Now you blacklist them, you finish them. Now we need to balance this, but the problem has since been abandoned. And some of the contractors were pursuing them. Some do not even have funds. So it's a challenge there, but currently the process is that if there is a poor performance, we terminate, recover whatever we have, and then we appoint the other contract. Now, as well, the blacklisting issue, it also has its own challenges as well. There's a fight left and right. In some cases, we have to recommend to Treasury, like the other matter of Bridge and others. It has since been returned, they were restored, there were court applications. This as well, they are opposed by big companies. But we are doing our best to revive it with the restriction committee, that process of restricting them. Because indeed, incomplete project, there has to be consequences. And The other question was, what does it mean by poor merits and good merits? Poor merits is to say, remember, when matters comes, you have to assess based on the summons and what you get from line function. If it's a project manager, to say, let's check here. The contractor is suing, for instance, to say 2 million for non-payment. Why non-payment? They say, no, it's a negative payment because we have overpaid there and there. Then you have to determine whether this contractor indeed is entitled to this. Now, where the principal agent and the project manager says, no, we have overpaid previously by this much, so we have to issue negative certificate. Now, that then tells you, and then we hear the version of the contractor. Now you are able to check, and the list of the issues of overpayments you are able to assess. Then you are able to say, no, here we have a clear good merit, a case to defend. This is not owing. Now, with regard to, that is a good merit in our case, and then poor merit in the case of the contractor, meaning that does not have a good case against the state. And to say, then linking that question to dormant matters, to say, how are we going to finalize them? Now, where we have got poor merits and the review is going to be conducted, if it is established and we're able to see that indeed DPWI has a poor merits, we have a claim, part and parcel is to say, we will need to engage in that ADR. The contractor will be consulted, we determine what value do we owe him, and then we pay. So that's how the recommendation should come, because it's to look at all angles from the independent advocate. And what are the causes of these civil cases is one question. There are a number of causes, like we said, Chair, that the report is minimal. In some cases, like your construction matters, there would be disputes around extension of time. The contractor would say, I could not buy material during COVID-related period because hardwares and this and theirs were closed. So I could not move in. So I'm entitled to extension of time with price adjustments. So there would be disputes around the project manager, the principal agent. So those are some of the causes. How they agree. They may not agree on other issues. This one they will call it a variation. This one they say, no, it's part of the scope of work. Those are the types of disputes that involve. Hence, we said, we believe that most of the case should be going through alternative dispute resolutions because they are clouding the courts. The disputes are purely technical. These are disputes that could best be dealt with by independent experts in the area rather than the courts. And mediation or alternative dispute is faster, cheaper, and they create that friendly environment. The other question was the register of defaulters. Yes, there is a register for defaulting contractors that is kept by Treasury as well. Every time when the SCM has to award, they also refer to that. But from the labor relations side, the engagement with them, we know that they keep the charges of those employees who have resigned. And there is once they rejoin the state, we have a responsibility to transfer the file to the other department to pursue those charges. And public works witnesses would also assist that side. I think these were the questions, but just to indicate on the issue of SCM system, to say, are the checks and balances, the experience we've had with engagement with the procurement process, it's not fully proved, Chair, There are ways and means how people maneuver and so on. The forms that are completed by contractors are clear even on conflict of interest issues. Are you related to so-and-so? Are you employed by the state? But still companies, when they complete, most of them, they do lie as well. And you can only recover, when there's collusion, you only discover in most cases when the other one decides to report. Then we're able to then know, and then they stop the payments. But definitely the checks and balance in terms of documents are there, but verification maybe it's one area that need to be checked up to say, can we screen? Because there is a screening of the companies, but the screen by security, which looks into various issues, criminal records and so on. Maybe it should also be expanded to check whether they are also employed by the state or not. Chairperson, thanks. I'm not so sure if I missed some of the questions. I may still be reminded. Thank you, Chair, and thank you, members.
Thank you, Mr. Christopher. Thank you, Mr. Lwazi, on your responses. I can see that members, they want a second bite in some of maybe follow-up questions on the questions that they have raised. Just before I take the hand of Honorable Hicklin, as I say that, okay, and there's also Honorable Graham Murray. There's an issue here that sometimes the department would take orders because a case has been lodged with Public Service Bargaining Council, sometimes CCMA, sometimes labor courts. And maybe the time to deal with that case would then necessitate that the employee comes back to work. Sometimes the contract of the suspended employee also comes to an end during that time that you are dealing with reviews and that. So what I want to check is that if that employee has been suspended maybe without pay, and then his term in the office ends during that time, what happened to the money owed to that employee, like salaries and all the benefits that that employee was supposed to get? Or sometimes not necessarily the contract ending, but that employee, because of the delay, has to come back to work. What happens to that situation? Thank you. Then, our minister is back. I think she will speak after the two hands that I see in front of me, Honorable Hicklin and Honorable Graham Murray.
Thank you, Chair.
Yeah, thank you.
Thank you, Chair. Mr. Makoba, you said
this is the last set of round where you will be commenting and asking questions, honorable members. Honorable Hicklin, followed by Honorable Graham Murray.
Thank you, Chair. Mr. Makoba, this is something that, for example, I have committed an offence in this particular committee or this particular department, and you process a claim against me, that you hold that record and that it can't, once my name is registered, that I can't go and work in another department. How long would you keep my name, for example, on a register and not allow me to work within another department? Did I understand that correctly? And if I did, how long would that name be kept on a register, and is it made universally known? Because I think that's the biggest problem that we have if I am an SMME, because what I think we're finding is not only is it SMMEs that have to be sanctioned for committing an offence, I think it's also officials that are sanctioned or found to be wanting within a department, those officials must also, a list of those officials must also be kept, so that if somebody commits an offence and is convicted of committing an offence within the DPWI, they must not be allowed to then go to health or to communications or to any other department. I think that is the point that we were making earlier. So it's not only SMMEs that must be prevented from doing business with the state. It must also be officials who are within a department who cannot now actually get their records wiped clean and then can then move from DPWI to DHA or anywhere else in the department. Did I understand you correctly when you were talking about SMMEs? But if it is, it must also apply to officials within government. Thank you so much.
Thank you, Chair. I'll go straight in. Yeah, I think the chair raised a pertinent issue that I also wanted to ask. So effectively, what is the, and I think this relates to what the minister was saying, is that the department itself doesn't actually pay for legal services. I mean, they use the state attorney. Obviously, they've budgeted an allocated amount, but it's not like any other organization where you're paying an attorney and you're alert to the fact that you've got these huge legal bills. So I think what's happening is that we are taking cases on review to Labour Court and losing them. And that's obviously got a cost implication for the department. And in the interim, while these things are being fought and debated and everything, contracts are expiring or people are leaving, or you know, there's no money that's being paid back to them. So I think that's one of the issues that we need to look at, is whether or not we are taking cases on review just because we can, or whether or not we're taking them on review because it's in the interests of the department to do so. And then I think the other question I wanted to ask is, the construction mafia and the pressure from SMMEs, particularly in small towns, is immense. I'll give an example. In Patterson, there's a police station that was being built, and for weeks, that construction company was held to ransom because the SMMEs were demanding certain things. And in fact, what often happens is they demand 30% of the entire contract fee without actually even being prepared to work for it. They often just go in and say, you give us the money and you can cover the costs or whatever. And so you're finding that these EOTs required, there's delays, there's additional costs, there are overruns, etc., because companies are being held to ransom by the construction mafia and the SMMEs. Are there cases where contractors have been found guilty of poor performance or failure to perform as a result of these issues? I know there's been issues at the Yobatina, I think it's the Yobatina SAP station. There were issues around SMMEs holding the contractor to ransom, and the same thing I think applied at the Sarah Botman Centre of Remembrance as well. So that is something that I think we need to be looking at as well as a mitigator in terms of non-performance on the part of the contractor, which is not necessarily their fault. Thank you.
Minister?
Chairperson, I didn't leave yet. Quickly, in the first round of questions, we didn't respond to your concern about the repeat findings in terms of the PFMA, and also to Honourable Graham's concern about targeted interventions. Now, the system that we've put in place is that quarterly meetings with the external audit, I will then write to the accounting officer with remedial actions that must be implemented. And the PFMA is clear in terms of Section 38, 39, and 40, the role and function of the accounting officer. But still, honourable members and chairperson, our biggest problem is that the resistance to IT. And because a lot of things is being done manually. So we have employed a new Chief Information Officer, Ms. Malapela. She started in July. She has already made a lot of changes. She's a very smart lady. And we have also put out a tender to digitize the immovable asset register. We have approached Minister Nchaveni to give us an expert team together with the CETAs to come and look at our whole ERP system and digitize the whole system. So that is all work in progress. So we do targeted interventions after the External Audit Committee gives some findings to us. So I just wanted to answer that question as far as that is concerned. Just in terms of no employee gets suspended without pay. That is part of the Labour Relations Act. But I think Chris can give further details concerning the Labour. It's an old case that was launched by Minister Nessie in 2018, 2019. Those files got lost, but only after I had to intervene with the Judge President of the Labour Court to say that we are still waiting for a date 2 years later. And then they found that the files were stolen and we had to reconstruct the file. And the key point here, Honourable Chairperson, is that we have to decide on the merits of the case before we decide to defend. And that is what is missing. The delegation to just defend any case is with the accounting officer. So we are now putting a system in place so that we check the merits of the case before we decide to defend. So the point raised by Honourable Hicklem as to how long do the name is kept and of employing a person that was fired out of government. There was just a recent court case about 3 months ago where there was a judgment against the Western Cape government for employing a teacher that was found guilty of sexual harassment. So we now also have legal precedent as to what government must do when it comes to an employee that resigned or was fired in one department and go to another department. Concerning the construction mafia, Honourable Gremere, I have the information of the Jopatina case. What happened there was that the Department of Public Works put in a recommended SMMEs that the contractor must employ from the database of the department. And then the contractor chose not to use all of those or some of those SMMEs that the department has given to them as part of the tender specifications. It then went to court and the tender was cancelled because of that. But I can get the full details and forward it to Honourable Gremere. I'll have to find out exactly where is it in the litigation process. But I was aware about that. So it was not the construction mafia. The construction mafia is very, very active in the country. Just 3 weeks ago, we launched the Salvaco Precinct bulk services that we started rolling out. And the day before, they threatened us that we were not going to launch this project. They've been chasing off the contractor a couple of times away from the site. I then contacted Commissioner Masamula and the minister, and I was advised about the specialized units that they have in each province now, where contractors can report the construction mafia. We went ahead to launch the project the next day, and the police came there because I said we're not going to be stopped by the construction mafia. They also call themselves business forums, and they're demanding this 30% share of the contract. Unfortunately, some of the contractors pay just to get along with their work, but that is also unacceptable. So maybe at some stage we can bring a report to the community, to the portfolio committee, or you can ask the Minister of Police to come and give you a report on the response of government to the construction mafia. Thank you, Chairperson. And now I'm going to have to leave, but Deputy Minister is in the meeting. Thank you very much for the opportunity, and goodbye.
Thank you, Minister. Thank you. Can we get the responses from Mr. Christopher and Mr. Lazi on the questions raised? I know that Minister has partly responded to some.
Thank you, Chair. On the issue of the suspensions, yes, the Minister has addressed it. Indeed, she is correct to say that in the department, and as part of the application of the Labour Relations Act, the department, such as ours, cannot suspend employees without pay, especially arising out of misconduct or precautionary suspension. But the suspensions without pay, those that are implemented as part of sanctions after an employee has undergone a disciplinary hearing as a sanction. And they range from between 1 and 2 months, but that would be a sanction. And the normal principle is that when an employee has challenged the suspension, because suspensions is always implemented with pay, then it means now the suspension is set aside and can come back to work and resume duty. So there wouldn't be any disadvantage there in terms of salary. Now, where the employee has been dismissed and goes to bargaining council confirmed that the employer followed a fair procedure and had a fair reason, they go to Labour Court review and set aside the award. Then it will order reinstatement. Now, what does reinstatement? It means you are reinstated back to your employer. Then the employer will reinstate you and pay all your dues as if you were not dismissed. Now, that is the remedy. Unless if the employee chooses compensation as one of the remedy, then you are compensated according. Now, compensation is limited, is prescribed in terms of the Labour Relations Act. It's 12 months for ordinary cases, but for unfair dismissal, maybe on the ground of a listed ground, which involve unfair discrimination and other things, then it's 24 months. So those are limited. Now, but for the department, we do implement everything. We do not have a situation where the employees were suspended precautionarily and then without pay. That's what the standing rule are saying we are applying. Now, on the issue of construction mafia, just to add, yes, indeed, there was one case that we've had in PE, like the minister has said. Local business people complained to say that they are not considered, especially for subcontracting, and that the department would appoint a contractor from another province, and the contractor will come with his or her own subcontractors, and they are saying they are not benefiting. Unfortunately, with this 30% subcontracting, which is prescribed by WPFA, we usually, when we appoint contractors in the department, there is even a list provided by the department from National Treasury that keeps a database of all the subcontractors, where these are given to bidders who have to go and make a choice of which subcontractors they can use, and for that. Now, when the tender is evaluated and awarded, it's awarded even with the list of subcontractors who have been verified and confirmed. Now, in that case, when the local business forum started to disturb the contract, Then the contractor had to launch an interdict. Part and parcel of what the minister is into was to say, no, let's look at the merits and get information first. Was to say, then we had to look at the entire projects and to confirm who are the subcontractors, they appointed fully, and it was discovered when we assessed that no, the subcontractors utilized by this main contractor are not the ones who have been approved with the tender. Now, that's one area which was not monitored properly, because once the contract is awarded at an SCM level, the implementation on site, then that's why there's an implementation guide now. So when we award tenders, we include a form that is completed by the main contractor to say where the subcontractors, their names, and the value of the work that they are going to do. So that would help in terms of monitoring the distribution and as well as the payments. So that's one challenge. Indeed, we hear of those incidents. Maybe the construction management branch can have those incidences which have not been reported. We've heard that in KwaZulu-Natal, they are male, and we also had somewhere in some locations in Gauteng, they are also prevalent. But the branch can be able to give a brief to the committee on the prevalence of this. Now, the second question linked to that was the issue of, are there cases where companies whom we have contracted are held liable for costs arising out of this riots with no fault on their part? In such cases where there are delays that are beyond the contractor control, the contracts we utilize, they do make provisions for that. Now, what then happens, they launch, and the contractor has to launch an application for extension of time. And if there are costs involved, yes, and factor in the cost, that gets adjudicated by principal agent in the department, and it gets approved. There wouldn't be no penalties. They have to prove it, submit it in the form, and then we get approved. They are not punished or even where we charge penalties or we cancel. Now they have to apply for that extension of time, quantify it, as well as the price adjustments. That's how we deal with it. I'm not so sure if the question by, there's another question to say on the register that we have for defaulting contracts, is there a register for officials? On that question, I'm not so sure about it. That's why we say we'll verify with labor relations whether we keep a register of employees who resign midway disciplinary hearing. But what I do know is that they keep the charges, and we have a responsibility. If they resurface somewhere, then this department will have to transfer the file to the other department, and that department can then proceed with disciplinary. But whether that register is fully proved, it doesn't have loophole, is what we need to check, and whether it's centrally controlled. But we will check with the labor relations and give the report to the committee. I think I've addressed the other outstanding questions, unless if Chairperson, I've missed one question. Thank you.
Chairperson, if I may as well.
Yes, please, Mr. Lwazi.
Yeah, no, just adding to some of the questions that are raised, in how we are dealing with also the issues of the construction mafia. DDG Faisal Imtiaz sits in the JPS cluster. Basically, the Justice, Crime Prevention and Security cluster, the cabinet cluster. So a lot of those issues are being discussed. There's a report that has been raised, that has been released in terms of the state of these matters. Now, I sit in the GSKID, which is basically the Governance, State Capacity and Institutional Development Cluster, which also discuss these issues driving the priority one of the developmental state. And part of this Construction Mafia is also looking at how can the state intervene in dealing with these issues of mafia, because they have an impact on the development and the communities as well. So this is just to say that part of this, we are discussing it at the cabinet cluster level, and we're bringing it, also discussing it with the construction project branch and giving effect on how, through our construction projects, how we also handle these matters with that. So that's basically some of the initiatives and interventions we are carrying out in the department to deal with these issues. And then working with the SCM and contractor management issues, dealing with the 30% and the interpretation of that 30%. It also goes in with these cabinet cluster discussions. And I think they will eventually be a government-wide response to that matter. Thanks, Chair.
Thank you, Mr. Lazi and Mr. Mahopa, also appreciating the contributions that were made by the minister, though she has since left the meeting. I had to switch off my okay, let me put it back. Okay. Members, this meeting, I think it has demystified some of the issues that we have as the portfolio committee. But one thing that you must understand, DM and your team, is that we will follow all these things that you are raising up in this meeting, because some of the issues, as much as you have not told us exactly which company has taken you to court, which company you're dealing it with court, we may have some examples, as Honorable Graham Murray has indicated and Honorable Trink on the issue of Port Elizabeth. There is an issue here. You may not respond today because as the portfolio committee, we are going there. There's an issue here of Telkom Towers, which started, according to the report that we got from you 6 years back, only one tower has been finished today. And the question that we're asking ourselves as this portfolio committee is that, is it still the same company? Have you changed companies in the process? You still have other towers to finish up. You know, the issue of Telkom Towers is a sore thorn. And as this portfolio committee, we have an obligation to ensure that the public purse is spent where it is supposed to be spent, not giving money to a contractor that a project that was supposed to be 3 years up is now on the 7th year. It's something that we cannot keep quiet about as the portfolio committee, but we appreciate that there is work that is being done. And also we support the unit and the strengthening of the unit that will look at compliance issues. But we really appeal that the positions that are funded, they must be filled. Employing 1 or 2 persons reduces the number of those that are unemployed out there. With those words, today we don't have minutes to deal with. I think this was the last item in terms of our agenda. Do we have any announcements, Ms. Medi, according to you?
No, Chair, not from my side.
Okay, thank you. But I think this announcement, it needs to be stated clearly that as much as we come to Parliament as different political parties, but there are people, even in these political parties, that they have flown the South African flag high. The late Deputy Secretary General, Ambassador, who passed on earlier when we were in recess. The ANC caucus will be having her memorial service tomorrow. So the reason I'm stating this here is because I think everyone across all political parties knew her, and she was once an ambassador for the country. So that means that we bow our heads, we give her the respect that she deserves, and those that are coming from the ANC will grace a memorial service. And even those that are not coming from the ANC, knowing what she did for our country, fighting for the freedom that we are currently enjoying, maybe we'll watch her memorial service through the YouTube and all the platforms that it will be shown at. Thank you again, honorable members, DM and your team, and our support team for such a progressive meeting today. The meeting is adjourned. Thank you.
Thank you,
Thank
Chair.
you. Thank you, Chair.
Thanks, everybody. Lekker meeting.
Bye.
Recording